changes in this term on the DSA, but I think this structured public hearing with external experts will allow us to get an even more informed overview of where we stand with DSA enforcement, what are the next steps, but probably where there are also challenges. So I'm very happy that we have a distinguished long list of experts here in this room with us. Welcome to all of you. Thank you so much for participating at our hearing. That is very, very important for our committee. And you would know that the meeting or the hearing will be structured in two parts. We have two panels. After each panel, we do a round of the political groups with questions and comments, and then, of course, the experts can reply, and then we have a second panel. So without further ado, let's directly start with the first panel on gaps in the DSA enforcement and compliance, a reality check. And we start with the European Commission as speaker. I welcome Prabhat Agarwal, head of the Digital Service Unit at DG Senect, and of course also a long-standing guest in this committee. And at the moment I don't see him. There, hi. Hi, Prabhat. The floor is yours. You know that all of you have more or less 9 minutes, so please try to stick to the time, because then we have also more room to still also discuss and take the questions from the members. So the floor is yours.
Thank you, Madam Chair, and thank you to all the members and all the colleagues who are here today for your interest in the Digital Services Act, and pleasure to be here as ever. And also looking forward to a very interesting session. So I'll make a few introductory remarks from the European Commission side. I'll be making 4 different sections in my intervention, and it'll be less than 9 minutes, I hope. I'll be giving you a very brief update on the work on the different cases that are open, and then I will be speaking just very briefly about some of our guidelines work and work on the Data Access Delegated Act. I'll be speaking then in the third section a little bit about our collaborative approach, both with national regulators, the DSCs. A pleasure to see John Evans here as well, with whom we work very closely, but also to shine a little bit of a spotlight on some of our collaborative work that we do with platforms in the third part. And then before closing, I'll just simply say a few words about a broader theme under this mandate, which is simplification, which is also in the application of the DSA a very important message. So those will be my 4 sections of my short speech. To begin with, just an update on our casework. We have currently 10 open cases of suspected non-compliance under the DSA in 4 priority areas. And it's important to just stress those priority areas again. They were reconfirmed by the Executive Vice President Virkkunen in her parliamentary hearing as well. And they are first and foremost the issue of non-compliant goods on online marketplaces, the effectiveness, secondly, of illegal content mitigations on some of the social media platforms. Thirdly, the issue around transparency and election integrity. I'll speak to that very briefly. And the fourth area of focus in our work is the broader set of issues around protection of minors. Now, I'll only give you highlights, of course, otherwise I'll be speaking for far more than my allotted time. So just to stress some of the highlights. In the area of online marketplaces, we're currently investigating for suspected non-compliance 2 platforms, AliExpress and Temu. The issues that we are investigating are the issues of the proliferation of non-compliant goods on these platforms, but also issues such as rogue traders and the issue of repeat infringers or repeat infringements on the platform. So this is about illegal products reappearing on the platforms or identified rogue traders continuing to do their business despite enforcement actions of the platforms. Amongst these 2 cases, I think the AliExpress case is the most advanced case. And while I can't really say anything about the details of the detailed investigations nor the timelines, I can confirm here that both platforms are cooperating very closely with us, have supplied all the data and documents that are necessary for our investigations and are responsive to our requests, which is, of course, a precondition for effective enforcement and also a good sign for coming to conclusions on these cases quickly, which is, I think, in everybody's interest. Now, let me briefly turn to an issue of illegal content procedures. And as you know, DSA is a content-agnostic framework, so our enforcement focus is not on deciding which content should be online and which should not be online, but it's clearly and squarely on the effectiveness of internal procedures of these platforms. So particularly, we have been investigating the notice and action mechanisms of two platforms, Meta and X, where we are investigating whether the flagging mechanisms are easy, effective, and transparent for users. And we're also investigating, in the case of X, whether mitigations more broadly against illegal content, such as terrorist content online, are effective. And as some of you may know, they have also been subject to independent audits, some of these provisions as well. The third focus area has been that of transparency and election integrity. And transparency, I know, has been a very important element also to this House when we were negotiating, in particular also issues such as the data access provision and the ad repositories. We have launched multiple investigations on those two provisions. And specifically, in addition to data access and ad repository grievances, we have also launched two formal cases against X and against TikTok, where it concerns coordinated manipulation of the systems, including the recommender systems, and in the case of TikTok, also the policies on political ads. Again, it's just very important to say that that both platforms are cooperating with us. In the case of both X and TikToks, we have also ordered a data freeze through a retention order. We have this is a kind of evidence freeze step, which we have only taken in two particular cases, X and TikTok. In the case of X, it concerns the changes to the algorithm, and in TikTok, it concerns more widely content that and procedures and processes that have a relevance to the election integrity work on these platforms. Now, let me briefly turn to the issue of protection of minors. There we have two important cases against Meta and TikTok open, which focus again on recommender systems, age controls, and issues such as addictive design. We have coined the term rabbit holes in some of our opening decisions, and these are indeed what we are investigating. We have compiled very far-reaching technical documentations of these recommender systems, and have been analyzing them together also with the European Center of Algorithmic Transparency. This is just a brief flavor of some of the casework that's going on. Let me now turn very briefly to the second part, is to give you an update on guidelines and the Delegated Act. Of course, we have heard the call from many stakeholders, including the platforms, on greater clarity on certain elements, but where guidelines were foreseen on the Digital Services Act. So we have been working very intensely, notably on the protection of minors guidelines. Some of you will know that we have already launched a call for evidence, which produced hundreds of responses, and we have been analyzing those responses and produced first internal drafts of such guidelines, which we will also hopefully soon make available for public consultation. I just want to stress here an unusual step that we have also taken with the Delegated Act on data access, that we actually consult twice, once on the evidence base behind some of these, and then again, typically we try and, for extra transparency, to also consult as much as possible on the near final draft, so that we actually get input on several stages. I think this is a very high degree of transparency for secondary lawmaking, and we have benefited a lot from stakeholder feedback as well. And for the protection of minors guidelines, we will also do so. I can already give some of the elements that will very likely be in these guidelines. I think it's just at least, of course, a working level. I need to make a disclaimer that this is not yet finalized by the College of Commissioners, but the areas that are in focus of our work are firstly age assurance and also the adjacent issue of parental controls. We'll be looking at default settings for minors when they go online with these accounts. And of course, the first two are linked. You need to have some kind of assurance that a minor is of a certain age. Otherwise, the issue of default settings doesn't really make much sense. You know, and the circumvention to these age controls is also something that we are investigating in some of these open cases. We have also heard from stakeholders a really strong desire to go further on issues such as child right impact assessment. Sorry, I'm already at 9 minutes. And we have also we will also be making some recommendations on in platform governance best practices. Let me then actually race to the end of my things. Just my two final points, if I may. One is on the collaborative nature of our work, where we have been working very closely with the board. 8 working groups on issues that include also protection of minors, where issues such as age verification and so on are discussed. But also with platforms, we have instituted now a more, let's say, a dialogue, a regulatory dialogue format where many issues which can be resolved without going to formal proceedings, and this has already shown some good results. Now let me close with just one final point, is that a strong point of the Digital Services Act is, of course, the maximum harmonization. The fact that we have a single market set of rules instead of 27 different rules is a big, strong asset for us, and we will continue actually to really push this very strongly, and the board here has a very big role to play also in the consistent application across the European Union, also for smaller platforms, and I know we'll be hearing from some of them in this meeting as well. So I'll close with this. For me, the DSA enforcement architecture is expanding, is unfolding, with national regulators strengthening their teams and refining their powers. We are not slowing down our work, and quite the contrary, we're working at full speed. And my final point is that a single set of rules is still the best way forward, and we are committed to fully enforcing the DSA as we go forward. Thank you very much.
Thank you so much to the Commission. And now we move over to the business side of things. I'm happy that we have Konstantin Gisler, the Director General of .Europe. As you know, the united voice of the leading internet companies in Europe. It is their self-description, I think. So welcome, Mr. Gisler, and you also have 9 minutes.
Thank you, Chair, honorable members. Thank you for the opportunity to contribute to this important exchange on the implementation and enforcement of the DSA, which comes at a key moment of its existence, I think. The DSA is a landmark regulation for Europe, establishing a comprehensive framework for online services that balances responsibility, legal certainty, and innovation. Yet, as with any ambitious regulation, success depends not just on the law itself, but on how it is implemented. The way authorities enforce provisions, how business comply, and how the framework interacts with other regulations really is key for its ultimate impact. Now, while the DSA has been enforced for 2 years, we're still in the early stages, as we've also just heard from the European Commission, and we were not yet seeing its full implications. This is a period of firsts. The first platform transparency reports, the world's first comprehensive content moderation database with now more than 10 billion decisions being recorded there and publicly available. The first risk assessments, independent audits, and regulatory dialogues between companies and authorities. It is too soon to draw definitive conclusions, but I will try to highlight today what so far has worked well and where improvements might be still needed in the future. Before I start, a quick word, even if the chair stole my thunder there. Yes, we're the leading voice for the online services in Europe, from search to social media and video sharing to e-commerce and travel and many, many more different kinds of services. While some of our members are very large online platforms, and we actually feature most of the ones designated, the majority of our members are smaller platforms and are not under the supervision of the European Commission. And I think it's really important that we also hear their experience here today. What all of our members have in common is a strong commitment to compliance and a constructive engagement with policymakers, regulators, and civil society. Now, what has actually worked well in the DSA? First of all, I think companies appreciated that we now have a horizontal, principles-based approach that provides a flexible, future-proof legal framework for online services across very diverse sectors, avoiding overly prescriptive sectorial rules and a patchwork of multiple national rules. Second, the continuous regulatory dialogue embedded in the DSA fosters cooperation and a better and deeper understanding between platforms and authorities, rather than relying on enforcement after the fact. Third, the DSA retains proven principles from the past, such as the intermediary liability restrictions and the country of origin principle, ensuring stability and legal certainty in the single market. However, there have also been challenges, some of which might be just teething problems. One of the biggest hurdles was the maybe overly ambitious timeline that was provided by the co-legislators. Very large online platforms had to comply with the DSA in just 4 months. The first transparency reports were due 3 months later. That is unprecedented, to my knowledge, in EU regulation. Meanwhile, many national authorities were not yet designated or were not yet given their full powers, leaving smaller platforms without clear interlocutors for most of 2024. This also affected key features of the DSA, such as trusted flaggers, the vetting of researchers, and the transparency database, which requires onboarding of smaller platforms, all of which require the involvement of national digital service coordinators. At the EU level, and we've just heard it from the European Commission, more than 2 years after adoption, companies are still waiting at least for one secondary legal act and further guidelines and potentially more codes of conduct. That said, I want to acknowledge also for a moment here the significant efforts made by both companies and regulatory authorities over the past 2 years, particularly actually the European Commission, as the lead enforcer role was actually originally not even foreseen in the DSA, which we may have already forgotten by now. Within just a few months of the adoption of the DSA, what was initially a policy unit had to be turned into an enforcement division that only 5 months after the DSA entered into force issued its first legally binding decisions designating the first VLOPs. To put that a little bit into perspective, that's shorter than the time it took the European Parliament's administration to do the procurement process for new canteen and restaurant service caterer. Now, I'm not saying that for the comical effect, but I think also to make a serious point here. Timelines really matter. Of course, deadlines can reflect the political urgency of a regulatory goal, but they also need to be realistic, and that means reflect the required implementation compliance efforts. It is crucial the co-legislator is mindful of that also for the future in order to ensure effective laws. A second challenge is the growing overlap between the DSA and other EU regulations and national laws. Online services must navigate a complex patchwork of overlapping obligations under such laws, such as the European Media Freedom Act, the Audiovisual Media Services Directive, rules on terrorist content, political advertising, online consumer rights, and now the AI Act. While not today's focus, I want to note here also that we do have some concerns about the envisaged Digital Fairness Act. When I'm listening at the debates that we currently hear at the committee level and at the plenary level, we do see a lot of issues being addressed that were also just mentioned by the European Commission, which the Commission already has the powers to address and the DSA covers. The digital rulebook has expanded significantly over the last couple of years, requiring companies to continuously adapt to new and changing compliance demands. That's why we strongly support the comprehensive digital fairness check that the European Commission has announced for the end of this year. Now is a good time to assess, to ensure coherence, prevent duplication, and create a more effective regulatory framework. As a third challenge, I want to mention the administrative burden, as was also given to us as a task for this hearing, that the DSA places on large and smaller companies. These providers of online services must submit transparency reports, active user disclosures, risk assessments, and respond to numerous regulatory requests from authorities, on top of similar obligations under the Terrorist Content Regulation, the Code of Practice on Disinformation, the Future Child Sexual Abuse Regulation, and the Political Advertising Regulation, to just name a few. The accumulation of these obligations risks turning compliance into a bit of a box-ticking exercise rather than a meaningful accountability process. We urge the EU policymakers to streamline these reporting requirements so that both companies and regulators can focus on the most relevant insights instead of being overwhelmed by the paperwork. Looking ahead, to ensure the DSA remains effective and workable, 3 issues should be prioritized. First, improve stakeholder consultation processes. I've already mentioned the tight deadlines, so I'm not putting necessarily the blame here on the European Commission, but while industry has been actively engaging on numerous of these discussions on codes of conduct, delegated acts and guidelines, the timelines were often very, very short. We had very little warning ahead of these consultations, so it was difficult to provide actually facts-based and informed contributions to these. And often these are actually about key aspects of the DSA and its implementation. A more structured and iterative approach would be helpful in the future. Second, according to the country of origin principle, each company has a single primary regulator, its home country digital services coordinator. However, in practice, both very large online platforms and smaller platforms continue to receive requests, often informal, from multiple national authorities outside of their jurisdiction. Now, companies want to be cooperative, but they face the risk of setting precedents and creating future expectations in these situations. The Digital Services Board should ensure that the DSA's division of labor and competences is respected. Third and last, if the Digital Services Board takes on a stronger coordination role, similar to the European Data Protection Board under the GDPR, we should also learn from the lessons from the GDPR, which means ensuring clear roles, accountability, and proper consultation mechanisms for any far-reaching decisions or opinions the board issues in future. In conclusion, Chair, honourable members, as I said at the outset, we're in a period of firsts. For the DSA's success, we need to focus on legal certainty, regulatory coherence, and a fair and proportionate compliance approach. Much has been achieved, but further work is needed on all sides. The DSA is a dynamic regulatory framework that has already brought significant changes to online governance, but will only fully realize its potential over time. The European Parliament has played a key role in shaping the DSA, and hearings like this one play an important role in keeping us on track in the implementation. .Europe and its members remain fully committed to this dialogue, and we look forward to continuing it with you. Thank you.
Thank you so much, Mr. Gisler, for presenting the business perspective on the enforcement of the DSA. We now come to the member states' perspective. I think digital service coordinators were mentioned already several times today, so we are also happy that we have actually one here, and I welcome John Evans from Ireland, so the Digital Service Coordinator from Ireland. Welcome. I think it's very valuable to also have your perspective on the enforcement.
Thank you. Many thanks for the invitation to appear before the committee today. As a new organisation, this is our first time doing so, so we're looking forward to the discussion. Well, I'm going to talk in three parts, hopefully within 9 minutes, about our organisation, where it's come from, what we've done over the last year and a half or so, what our ongoing work is, and some of our plans. So Commission Le Mans was established 2 years ago. It was grown out of a former regulatory body, the Broadcasting Authority of Ireland, where that organisation was 40 people. We are now 200 people, so it's been a massive expansion of the organisation in a very short period. And we anticipate that we'll be up to about 300 people at this time next year, all going well. We're led by 5 commissioners, one of whom is myself. I'm the Digital Services Commissioner. And I'll tell you a little bit about our divisional structure. We have our traditional broadcasting functions, so media development, broadcasting regulation. And then we have what we think of as our online safety side. So we have, and I lead this division, which is the Platform Supervision and Investigations division. We work very closely with our policy division and also our user experience division. And all told, I would say we have approximately 120 people of the 200 that are working on the online safety area. Our online safety framework is made up of, we have responsibility for terrorist content online regulation, some aspects of the AVMS directive, specifically our online safety code, and then also the Digital Services Act. And we take an integrated approach towards those 3 instruments in our supervision and enforcement activities. We take a risk-based approach, so there's a certain amount of risk-based approach baked into the Digital Services Act by virtue of the number of size of users and type of service offered, and we are building on that. So in addition to 15 of the 25 VLOPs which are established in Ireland, we also have responsibility for a large number of below threshold intermediary service providers that are also based in Ireland too. We really value the cooperation we get with the European Commission, and we've worked closely with them over the last period, and we think that cooperation with DSCs and the European Commission is very important for effective enforcement of the Digital Services Act going forward. So what are we doing for consumers, for example? On February 17th last, that was DSA Day, if you like, we got our powers for the first time, and on that day we opened up our contact centre. Actually, we opened it up as a complaints centre initially, but we quickly realised that what a lot of people needed was advice on how to report, for example, to the platforms, because the Digital Services Act is a systemic piece of regulation. As Prabhat explained, our role is to make sure the platforms are implementing the mechanisms, such as reporting mechanisms, complaint mechanisms, and so on, in a correct way. Our job is not to deal with individual pieces of content per se. So a lot of what we did through our contact centre was explaining and guiding people about how to report material online. Some issues did escalate to complaint stages. So because we are the Digital Services Coordinator establishment for a large number of the very large platforms, we take in complaints emerging from different member states. So we have taken in about 450 complaints altogether so far, and about 15% of them have come from Ireland. 85% of them have come from other member states through other DSCs. And we're very grateful for the cooperation of the Digital Service Coordinators Network for channeling good complaints in our direction. A big focus of what we've been doing over the last year has been making people aware of what their rights are. So I mentioned specifically how to report. We ran a campaign, Spot It, Flag It, Stop It. The object of that campaign was to just raise people's awareness about their rights. We've also developed a lot of educational resources, particularly targeted at children and parents when it comes to parental controls and other concerns that society has about participation by minors online. Thematically, the organisation has focused its objectives, and these cleave pretty closely to what the Prabhat explains are the Commission's objectives. Ours are children, public safety, diversity and inclusion as the opposite of hate online, trust and democracy. A big part of our work is participation in the Digital Services Board, so we're active on that board, and I participate on that board myself. We are very active participants in the 8 working groups of the board. A big focus on us it has been getting up and running some of the mechanisms, for example, around the transmission of complaints across the network. Getting complaints of a good standard is very important to us so that they can be actionable. There's a lot of firsts in the DSE, and the Digital Services Board and the working groups are good places to work out what the best way of doing them are. We are vice chairs of the working group that is dealing with minor protection. So we're leading some of the work there with the European Commission on developing the guidance around Article 28. We're also very active in the group, naturally enough, that is working on vetted researchers and preparing the ground for that. We'll be a key DSA for a lot of the processing of those vetted researchers' applications when that gets up and running. In terms of our supervision and enforcement activity, it's useful to sort of distinguish 3 levels of work that we see our work evolving around at the moment. First is working with the Commission, so we would support the European Commission in every way we can as an on-site local presence. That's a significant piece of work for us and will be in the future. We're also working very closely with the Commission on specific cases. We're associated with 2 of the TikTok investigations, for example. Secondly, we have initiated, so the work we're seeing on our complaint side and the information we get through the body of complaints. I was explaining earlier that it's about systemic regulation. So what we're looking for is patterns in the complaints that are coming to us. One of the areas that, for example, became obvious that was sort of attracting a lot of attention was Article 16. So this is the article that provides for the reporting mechanisms on platforms. People were telling us through these complaints that they're difficult to use, that they're not intuitive and so on. So we decided to initiate a kind of a thematic review across a selection of platforms, both above and below threshold, to look a bit under the bonnet about how that's going. That work is still ongoing, and we're gradually forming a picture of what that situation is like. Some platforms perform better than others, let's just say, for the moment. And then there is our below threshold work. So that group of 120 so platforms among a bigger group of 400 or so intermediary service providers that are established in Ireland, we're looking at are they ticking some essential boxes there? Are they publishing information about their user numbers? Do they have points of contact? And we will develop that aspect of our supervision work over time. A bit on our plans. On day one of Digital Services Act back in February last year, we were open for applications for trusted flaggers for out-of-court dispute settlement bodies. And that part of the digital services infrastructure is still coming online, I would say. So we certified one ODS body last year, and we haven't yet certified a trusted flagger, though we are about to. We thought to be much more interested in that mechanism, and we've gone out to try and actively promote it. So that's a piece that still needs to develop, I believe. And I explained a bit about what our experience so far is with the patterns of complaints and these thematic reviews. I think that will be a significant part of our work going forward. Role of the Commission. The European Commission plays a very important role. My French colleagues often refer to it as Team DSA. I think that's an accurate description, and the European Commission is the captain, if you like, of that. But all the members of the team need to play their role. And I think the Digital Services Act is something that politicians and policymakers and civil society groups need to see impact of in local, national areas. I think that's something we all need to work on as a group.
Thank you.
Okay. One last comment.
Okay.
Yeah. Oh, sorry, I'm over 10 and a half minutes now. If I was to make a call to the committee, it would be to encourage people to report content. I'm aware that there is, and to use the mechanisms made available to them under the Digital Services Act. It's very important that we're able to make use of that. Citizens feel empowered, though I'm aware that there's a certain amount of, if you like, reporting fatigue. We need to overcome that. It's worthwhile, it generates evidence, it enables us to ground enforcement and supervision activity. I'd make that call. Thank you.
Thank you so much to all the speakers. So this concludes the first round of the panel, and as I announced at the beginning, we now do one round of political speakers. I fear we don't have time for more, but again, we have also a second panel, and each time, obviously, we also start with our chair of the DSA working group. So I give the floor to Christel Schaldemose.
Thank you very much, Chair, and thank you for your presentations here today. It's really nice to hear from you. As you know, I was the rapporteur on the DSA, and it's really great to hear how it is out working there. First to the Commission and Prabhat, thank you very much, very, very much for your hard work. I know you're working night and day to make the DSA work, and I know it's not easy, and we are on you on a daily basis in order to make you do even more, but it's really appreciated what you're doing. Prabhat, could you maybe give a couple of examples on where it's possible to say to the citizens, here Here it's visible that we had the DSA. If it wasn't for the DSA, things would have been different. I think it could be nice to have a couple of very concrete aspects. And then on protection of minors, as you spoke very much about, and I appreciate very much what you're doing in that area. We have this arm's length principle in place as a part of the law, but we're also looking into how can we protect kids and minors even more. Is there already something you could say to us on that, where we could have done it differently or where we should do it differently? Because we're also waiting for to this new Digital Fairness Act to come in, and maybe we could do more to protect kids. I mean, have we really tackled the business model in a good manner? And to dot Europe, well, you said that it goes too fast with the DSA and the timetable. I'm really appreciating of the fact that we agreed upon having a very smooth and fast timetable. We are talking about digital businesses. We're not talking about businesses with a physical product, so it's easier for you to adapt. So I am happy that we already, after a few months, could designate very large online platforms. So I am, on the contrary, very happy with the very slim timetable we had. My question to you, very briefly, is you mentioned that we had too many burdens, too many things. Could you give us a couple of concrete examples? And if we should do something about that, what would the impact of that be? Because there are many good reasons why we put in the obligations. And finally, one question to the DSA Ireland. You want more people to report. Thank you for saying that. What are you doing with the reports you're getting? I mean, when I talk to citizens and they put in reports, they're saying that they don't hear anything. So do you also give replies back? Thank you very much.
Thanks. So now the round of political groups. Some of the groups signaled me beforehand who wants to speak, some not. So I will just go one by one. EPP, I think Abba Kokolari wants to speak, correct? Yes.
Yes, thank you very much. And thank you to Prabhat and the Commission for this very clear statement, and also for the representatives from DOT and from the member states. Have a few questions, as I also was a shadow rapporteur for the EPP on the DSA. I have a question to the Commission. Firstly, what conclusions do you make from the first round of risk assessment reporting, where the VLOPs need to comply with Article 42.4? Are they in need of any further clarifications? And a question to DOT Europe. You mentioned that you would like to make the reporting requirements to be more streamlined. Can you elaborate on that? How could that be done? This is the chance for you to be very concrete. And thirdly, it's a question to all three stakeholders, because it's so difficult today to report on illegal content on these platforms. You have to basically be a legal expert to report on illegal content. So what are you doing to make awareness to the public that they can actually report, and also to how to make it more easier to report when they see illegal content? Because this is the basics of the law, that we encourage people to report illegal content. And if that doesn't work, how can the platforms be aware of that there are illegal content, and how can also the member states then enforce this properly, and also for the Commission? So this is a very important issue. You need to step up on this. Thanks.
Thank you, Abba. Now for S&D, Laura.
Thank you so much, Chair, and thank you so much to the Commission, the business representative, and also Irish DSA coordinator for your explanations. Very interesting. I have some questions, basically, first of all, to the European Commission representative. You explained very well how the different proceedings are taking place, with no details, but of course we didn't address the elephant in the room, which is that the big CEOs, the big tech CEOs from the other side of the Atlantic, asked the President Trump not to implement the digital European laws to them, or to treat them as tariffs. So in this respect, we had a plenary debate in the Parliament. We know the official position from the Commission, but I would like to know by you, which is the answer that the European Union needs to give to these threats, to this blackmail, because the Parliament, we will be very vigilant. We want to know when the preliminary findings that were announced to X in July will be finalized, because in the hearings in October we asked about them. It's been several months, so I think it's about time to have a clear answer, to have a clear conclusion, and basically from the European Union to send a strong sign to the American companies that they cannot blackmail, that in Europe we respect laws. And I think that only they understand the language of power like they did with Brazil. And to the Irish DSA coordinator, you mentioned the trust flaggers, and I want to inform that today in the IMCO committee we voted a pilot project prepared by Crystal Scaldemose and myself in order to actually activate and foster that several countries that haven't yet identified trusted flaggers will do so. So you will have us on your side. So we hope that we can develop more these tools. Thank you.
Thank you so much. For PFI, Virginie Geron.
Oui, merci Madame la Présidente. Merci à tous les...
Yes, thank you, Chair, and thank you to all the speakers. I have a number of questions. I wanted to go back to a very important aspect, which is the cancellation of the presidential elections in Romania because of TikTok. When we look at all the different elements brought up by the press, I'd like to know more about the Commission's involvement. Because we've learned that before the election, the Commission intervened to monitor and verify the elections in Romania, and we see that the same day, the 6th of December, the Constitutional Court announced the cancellation of the elections, and we had the Commission's communication on the same day. So I want to know how the Commission was able to intervene prior to the first round of the elections in Romania. And my next question is to Europe, because you spoke about a lot of platforms, and the minority ones are less concerned by the DSA. So what obligations can be adjusted to prevent an excessive administrative burden? And my final question is to John Evans. Your country has a number of large platforms, so how do you plan to balance the national priorities and the European questions in terms of the application of the DSA in terms of freedom of speech?
Voi vorbi în limba română.
I'll be speaking Romanian. I have two simple questions. Firstly, DSA, Digital Services Act, is about protecting fair competition among operators, but moreover, it's about protecting consumers. So, do you feel encouraged by the need to comply with this regulation? And do you feel encouraged to create censorship and to compel users of these passports to respect community values or EU values, which are not necessarily the same as democratic, political, ideological, or political values? Do you feel encouraged to give users the choice? And do you feel encouraged or under pressure by the EU bureaucracy to somehow pervert the purpose of this regulation? Because it was basically about protecting consumers, but it is now used in order to apply a type of ideological and political censorship. I don't want to repeat what Mrs. Jean said just now, but I want to support her words. These are my questions.
Now for Renew, Svenja Hahn.
Thank you very much for the exchange on this, I think, most important legislation.
but also most controversially debated legislation. I mean, we already heard that the huge focus from most of the colleagues is on the topics around free speech, hate or disinformation campaigns, but we should not forget that the DSA also has a commerce aspect, and I would like to focus on the e-commerce aspect, particularly the illegal products sold online. We all know that Europe is flooded daily with millions of parcels with cheap and non-compliant goods, particularly from Chinese sellers. They're harming consumers, for instance, by having products that are dangerous, that have illegal substances, chemical harmful substances. They're also harming European businesses. Our businesses are strictly compliant with applicable rules when selling products, and they bear the high cost for this compliance. Those Chinese products do not. So they risk our businesses, they risk our consumers. And there are, of course, a huge number of violations of copyright and all kind of brands as well. So with the e-commerce toolbox, the Commission has presented a wide range of measures that could tackle this problem. I think we need better enforcement, first and foremost, particularly we need updates of the customs and the market surveillance. And the DSA is clearly the central tool to fight the flood of illegal products. And the Commission mentioned the ongoing investigations into the platforms, particularly AliExpress and Temu. And I know you cannot report back from ongoing investigations, but I would like you to elaborate maybe further on concrete measures that could theoretically be taken against these platforms selling those products. Particularly, what exactly can you require platforms to change, and what are the different stages of measures that can be taken against those very large online platforms, and how can the DSA help to get to actual third-party sellers and not only the platforms? And maybe you already see some positive impact from the DSA on these problems. Thank you.
Thank you very much also for touching upon the e-commerce, indeed also a very important part of the legislation. Well, for the Greens, Kim van Sparentak.
Thank you very much. And I'm speaking on behalf of our former shadow on the DSA, Alexandra Geze. So she has a question to the European Commission about the systemic risk of electoral influence by digital platforms. Because the study from Tabi et al. Shows that X gave very different visibility to different parties. And a specific study, AfD accounted for 15% of the tweets written, but for 39% of people's feeds, while Social Democrat accounts accounted for 12% of tweets written, but only 1% of the content of the feeds. And not all differences between the parties are explainable with different levels of engagement. So X decides in the end which parties are visible and which are not. And on top of this, another study shows that increased engagement for the AfD content seems to be boosted by bot networks. And we believe that social media networks deciding which party's content is boosted and which one is suppressed is a serious risk for freedom of expression of politicians and citizens, as well as a systemic risk for democracy. And the European Commission decided only January 17th to acquire information from X. And the deadline was February 15th, just 1 week from the German elections, and we still haven't heard anything about the results. So does the Commission agree that systematically suppressing the political content of certain parties and boosting others, in this case in particular parties closer to Putin, is a systemic risk for elections according to Article 34 and undue foreign influence? And what is the EU Commission planning to prevent such risks for future elections? Thank you.
Thank you so much. I don't see anybody from the left. ESN?
Ja, Frau Vorsitzende, vielen Dank.
Thank you, Chair. Since my party has just been mentioned, I could turn it around and say, why don't some media even download us? So that was a sort of cheap criticism. I'd like to talk about the trusted flaggers, and there I think that we have a resolution in Germany where pensioners who the minister has described derogatively are getting their houses searched by the police, being accused of terrorism, and that's been happening. The police coming in and then just kicking the door open and then off again. So that's what's happening in Germany. You don't need Digital Services Act for that. So my question for the Commission is, how can you ensure that NGOs that are registered as trusted are acting independently, really, and are not just being manipulated by other political forces or parties or citizens that are close to certain parties, so that they are suppressing other voices. And that's another important issue in order to defend democracy across Europe.
So now the speakers have the difficult task of replying in more or less 2 minutes, if you can, on the various amount of questions. And I give the floor first again to the Commission, to Prabhat Agarwal.
Thank you, Madam Chair. It's a long list of questions for 2 minutes, so I'll do my best. To MEP Schaldemose, there are a lot of great concrete examples, and I'll be happy to actually bilaterally engage with you I will just mention 2 here, which I think cover 2 aspects. I think, first of all, we have very good evidence that child protection measures that platforms have put in place would not be there even without the DSA. And we have, without telling the details, but I can guarantee you we have seen before and after DSA a gigantic change in protections. We don't think it's enough. That's why we need guidelines and more work. But and some of these, from some of these companies and individual ones, these were engineered specifically only for the DSA. They would not be in place, and it would be very easy for young children to access the content, which is made much harder now. The second one, category which I like very much, is the whole content appeals domain. The fact that you have appeals now you get information about something that happens to your content, that you can appeal and you can challenge it, and there's some great statistics out there also for out-of-court dispute settlements, that system is completely new. It gives new user rights, and this wouldn't be, this is very concrete for everybody. We have issues with the flagging mechanisms. I've already mentioned it, and I think that they should be used more, but they can also be improved. This is why we have investigations open, and once they work properly, I think this will also be a third improve. In terms of gaps, I just want to say that actually before the DSA, there has never been on protection of minors a really similar kind of law. There are some rules in the AVMSD as well, which we should not forget. But in Article 28 and 34, 35, it's really quite far-reaching. So before, of course, at nighttime we think of many things that we could have drafted differently, but in the morning when we wake up, we think, okay, let's work with what we have in the law right now. So I would leave it at that for now. To the risk assessment reports, I think they are quite varied. The question from the EPP, and I think that the good news is that every company has done a serious effort at it. And we have often heard more guidelines are needed and so on. And in the end, we didn't want to give guidelines for the first round because the platforms are all quite different. There's a big difference between Meta and AliExpress, for example. But in the end, I think on the whole, we were pleased by the fact that actually on methodologies were globally sound. The work was done seriously. And of course, in many cases, we had many additional questions, and so we asked, and there can be further streamlining and improvement in terms of the way they're done, but every effort was serious. It's out in the public domain, and I just seen today or yesterday also an important report from some civil society actors who have gone through them. We have engaged with platforms around these risk assessment reports, and we will continue to do so also in workshop format to further improve them. But I think these are very good basis for platforms to transparently externalize their risk assessment, make clear how they see the risks, and then to be public about the mitigation. So I would say a good first round with improvements still needed in some areas in terms of detail and quality and so on. To the US threats on tariffs, I think we are undeterred. I think this is our enforcement actions continue. We are ready to engage with the U.S. authorities, and last week Commissioner McGrath was in Washington, and I know that the IMCO committee was also in Washington, and the Trade Commissioner Sefcovic was also in Washington not long ago. So the dialogue on these issues are open, and from the Commission's perspective, we remain steadfast in enforcing our own laws, and we don't consider them in any way relevant to the trade discussions that are going on right now. On the question of the Romanian elections, I just want to take a moment because I think it's very important to clarify. I mean, just categorically, we did not and we do not interfere in elections. We have no competence in national elections, this is a clear member state's competence. What we have competence for is a very narrow and limited mandate, which is to supervise the company's risk assessments of election risks. And the way we do it is in two steps. One is that we have published last year guidelines on election mitigations, and I just want to stress the key part of these guidelines are better cooperation with national authorities, information flows, and transparency around what platforms are doing. So this is a really, really important element. And what a service that we offer is at the request of national regulatory authorities in countries where elections are organized. We assist member states in so-called roundtables. And roundtables are meetings with platforms, the different national regulators, and in many countries it's different national regulatory authorities. And these roundtables are very simple meetings where platforms explain what they do and national regulatory authorities explain what they do. And when there's a Q&A available, which covers exactly the items that are in the election guidelines. We do nothing more than this. So there has been no, and I just want to stress this on the record, no interference or no attempt to interfere in areas where we have no competence. We have a very narrow mandate, and we strictly adhere to this in cooperation with the relevant national authorities. So that's just a clarification. It's really important to me because I think we, as I said in the outgoing, we do not get into issues such as content. We do not get into national issues such as elections. What we do make sure is that if there is an issue, that contact points are responsive, that they are clear, that emails are available of who needs to contact whom when, and that we have a shared reading of what is actually in the election guidelines, which are public and can be consulted by anyone out there. Now, to the question on e-commerce marketplaces, I think it's a very important domain. It's actually Deborah is sitting next to me. She's the head of sector responsible for online marketplaces and is leading this work. We have two parts here to say what concretely we're doing. First of all, the DSA is actually the first instrument that actually makes the link between the third-party trader, and national authorities, because it actually mandates information to be transmitted from the third-party trader to national authorities. This never existed before. So before, you had no idea where the trader was from, who it was, and who you could complain to. So this is the DSA regulates, actually at the initiative of this parliament, these amendments were made by this parliament here, regulates transparency, know your business customer obligations, compliance by design obligations which are in the DSA, and these can be directly enforced. And so this is, by the way, also a really important part of the e-commerce toolkit that we mentioned, because it allows one thing that has never been happened before. Yes, the connection between customs authorities, DSA enforcers, and market surveillance authorities. And this is something that is completely new and that allows different parts to work hand in glove. And on top, we have all the mitigations against reappearance of illegal content and rogue traders. So on the question from the Greens and the trusted flaggers from ESN, just very briefly, so we have indeed ordered access to the algorithm from X on the 17th of January, and we have compiled internal documents. I can say only right now that we have been granted access to 6 different sets of algorithms by X, and this is being investigated right now. The data is flowing to our system, and the documents have been supplied. There have been some requests for extensions, which we have granted, also to give X time to collect more data and documents, and the data freeze instruction, so the retention order, has been implemented. I can confirm all of these 3 elements. The analysis is still ongoing, and we are very well aware of the research that you have mentioned previously, but at this point, Commission takes no position. Final point on the trusted flaggers. The DSA has very important safeguards so that the trusted flagger provision is not abused. This is in fact a really powerful tool to give fast access to content moderation decision, but there is a very high threshold for qualifying. If this threshold is not correctly respected, the Commission can take actions against national authorities, but also platforms and civil society can signal that these thresholds are not met, and actually the status can also be taken back if there are indications. So the trusted flagger is a privilege that you must gain by high standards, but you can also lose. So I leave it there. Thank you very much.
Thank you so much. So I gave you now a little bit of more time because, yeah, there were so many questions at you, but I think it's really, really important that you explain also again the facts. I think it's really important that we always, especially in this committee, discuss on the basis of facts. So thank you so much. But probably the other speakers can be a little bit shorter and stick to your 2 minutes because we are running late for the second panel. So now I give the floor back to Mr. Gisler.
Thank you. So I'll try to maybe address the questions because they went a little bit in the same direction, I think, Mrs. Joron, Mrs. Schaldemose, and Mrs. Kokalari. So I think overall, the administrative burden from the DSA throughout these whole risk assessment reporting requirements is quite high already. What I think makes it even worse is the fact that it overlaps now with other laws. Say the upcoming child sexual abuse regulation or the terrorist content regulation. All of these require also risk assessments and reporting, which means that while these are already systemic risk under DSA, the services need to produce essentially similar reports for the same services depending on when you adopted the law throughout the year, which means you almost do not stop reporting anymore. You go from one report to the next. Now, how to concretely solve that is a little bit more complex because sometimes these reports go to different authorities. We're well aware of that. But you could envisage, for example, to have one streamlined report. That is our EU compliance report, where you then enumerate the different laws that you comply with, so you don't have to report for each and every service under several laws. Because I think it's really getting now to a point where we're talking about 6, 7, 8 kind of laws for some of the services. Part, for example, where you've also been the rapporteur for the platform to business regulations, platforms still continue to produce annual complaints received reports up and until this day, which is a requirement which in a way has been made redundant now by the DSA, but has not been repealed. So these things continue to exist, and especially when it comes to substantial overlap, like, for example, between the ABMSD on minor protection and the DSA on systemic risks and Article 28 under the DSA, all of these could also produce similar risk assessments and mitigation measures. And then for companies, sometimes the question arises, which law, which article do I comply with now? There are subtle differences in the wording between these laws. How do I address them? Or can I just do, in a way, one report to rule them all? So I think that's one of, it might be a minor thing, but I think it will really open up a couple or more resources for more important things in the compliance work of the companies. Yeah, I think I'll leave it there.
Thank you so much. And now I'll give the floor back to John Evans.
Thank you. I'll be really quick. Again, I think a lot of the questions were kind of circling around the same kind of issues for us. When I was giving my call for action, if you like, around reporting, what I was referring to there is to support citizens in reporting to the platforms. Okay. And as Prabhat said a minute ago, where that's not working, and I totally accept that, you know, some people feel like they need to have a legal degree to be able to get through that process. That to me sounds like an inaccessible process, and that's why we have open some actions on those points. So we're working on that. Maybe just to say a little bit about our own complaints process. So once something comes to us and it's not a customer looking for some advice or something like that, but we think there's potentially a complaint here alleging a possible breach of the Digital Services Act. We'll do an initial validity assessment to see do we have enough information. We'll do a jurisdictional assessment then, This is all part of our initial assessment. That jurisdictional assessment will tell us whether this is for us, is it for the European Commission, or is it for our sister competent authority, the Competition and Consumer Protection Commission, because they have responsibility for some articles relating to marketplaces. There is a communications moment then with both the platforms and the complainant. We then move to a kind of a further stage of assessment, and we look a bit more deeply at the complaint at that point. Possible outcomes from that process are either we believe there's an infringement and we serve a compliance notice on the party. We can decide to open up an investigation, which would be a fuller process. We can dismiss the complaint if it's frivolous or vexatious. And this is often the case, most often actually, we put it in our bank of intelligence about the market so that we can spot trends and lead to these thematic reviews that I was talking about earlier. And again, after this, there's a communications moment with both the complainant and with the service provider. We're doing everything for the first time this year, so we're getting these processes. There's certainly room to streamline them, and we're working on that. But I would still maintain my call to action is to encourage citizens to report to platforms, and we'll work through that and make it better. Thank you.
Thank you so much. Thanks again to the first round of speakers. So because we are running behind, let's directly jump onto the next panel. It's called Strengthening the DSA Enforcement, Market Oversight and Consumer Protection, where we again have different stakeholders and perspectives, but equally important. We have a trusted flagger representative, independent researchers, and also, of course, the consumers here, like regular guests in our committee. So we start with Andronikos Kodrumpelis, senior editor, and Stamatios Akonotis, I hope I pronounced your names correctly, chief editors from Fact Review, and you are, this is what I understand, a trusted flagger, so probably it's very important to also hear your perspective. Welcome. You have equally 9 minutes, the two of you together.
Yeah, thank you a lot for the invitation. You can see a presentation of ours on the screen. So you can move to the next slide. I will try to be concise as the presentation is a report, our first report as Trusted Flaggers, which you can also find a link to in the last slide. So to clarify, we are a fact-checking organization which has been accredited by numerous networks, but a very specific part of our work is trusted flagging. Trusted flagging, though, is only for specific and extreme cases of this information. So our regular work is only about providing information to people, not about taking down anything. So, for example, if there is a deepfake or a fraud case, this is about trusted flagging only. If it is like a misleading photograph, it is not about trusted flagging or taking it down. Next slide. So, for our first report, we opted to focus on Meta. Despite that all VLOP is deserving scrutiny, we had to focus due to its leading presence in user base, as well as information about its very extreme ad fraud and deception problem. Next slide. So Meta has principles for advertisements, but even though they claim that transparency is very important for them, we have found in our review that many cases and many important aspects of the process remain unclear. Next. So there are a series of reports in the context of the DSA and DMA laws, but despite they explaining that the ad process is primarily based on automated systems to enforce its standards, we have not found data to verify that this approach suffices for consistent standards. Next. A very specific example is an indicator for accuracy, which is the rate of automated decisions that have been overturned after manual review in the entirety of Meta's moderation. This is the only index that Meta provides for accuracy. But actually, this index is completely relevant to how much infringing content fails to be identified. So this is really not transparent. Next. For human moderators, Meta does not report what percentage of flagged ads they review or eventually double-check. And for many languages, we found that Meta reports hiring only dozens of moderators for the totality of their work. There is no separate reporting for ad moderators. And when excluding international languages, we found like 160,000 users per moderator on average. And it's especially concerning that less prominent countries generally report even lower figures. So, for example, in Greece, we only have 30 moderators for 6.4 million users. Next, okay, this is the slide. So we know that in April 24, the European Commission opened DSA proceedings against Meta with two-sided reasons connected to this presentation. The impractical mechanism for flagging illegal content, which has been partially, it has been made a bit better, but improper handling of deception is still very much a problem. A series of independent analyses had uncovered networks of scammers and propagandists that had bypassed Meta's moderation. So an example of a very good report is a total review of the ads published in Meta platforms in 64 EU countries across months. This review found that most political ads were not reported as such, and Meta's automated moderation failed to detect the majority of them. These political ads were spared from stricter rules and transparency requirements during especially a very sensitive period of elections, either national or European. Next. Another example is the Russian disinformation campaign Doppelganger, which was first reported in August 2022, but remains active to this day. Meta has not managed to block it. The latest report on it shows that a Russian-associated entity has gotten political ads repeatedly approved by easily circumventing Meta's moderation. And here the paradox is that independent researchers could automatically detect the campaign, after the event of course, despite having minimal resources compared to Meta. Next. So financial ad fraud seems to be even more common than political deception. A 2024 Bank of Ireland survey found that 1/3 of adults reported ad fraud on social media, according to their knowledge. Nearly half reported ads for crypto investments, which is a common type of fraud, and we consider very likely that the actual rate is underreported due to lacking public awareness and training. So it is a very, very prevalent problem. Next. We also have some data that user flagging of ad fraud is often ineffective. So even scams that are very obvious to a moderately experienced user and very obvious to a fact checker or a moderator are often found non-infringing even hours or days after the report, presumably only by automated checking. There is also no obvious way to escalate a case to a human moderator with obscure exceptions. Next. A striking case where Meta even failed to stop the impersonation of its CEO was in 2023, a series of ad campaigns where Google and Meta were impersonated so that users were directed to install malware. And versions of a campaign were detected to be running in several countries for months. Next. Another big problem is that known scams are not consistently stopped. So a year of our investigation in a pseudo-medical product that was then institutionally denounced by numerous organizations, we still found accepted ads of the product and only part of them taken down. So even when Meta tries to take something down, it cannot really match the lowest threshold. We just searched on the ad meta library with the name of the fraud, and even we could just find these advertisements, but Meta couldn't. And when we made this report, we just tried searching for cryptocurrency in Greek our language, and an ad fraud was brought up in the third result. It was so prevalent and nobody had seen it. Next. We also tried to have a 1-month experiment. So for the purpose of our report, a user offered to record every instance of ad fraud that he came along his everyday usage of Facebook. and he recorded 36 separate scam instances, with some shown to him multiple times. We have recorded all of them. Next. Another really worrisome, we think, case that came up just while we were finalizing our report was that a NEDMO investigation, this is a pan-European network about disinformation, a post about an investigation that was about a Russian network of inauthentic behavior was taken down because Meta alleged that our report was inauthentic behavior. So the complete opposite. There was no obvious way to appeal at all, even to an automated system. And we asked around the community, after our finalizing our report, more organizations across Europe had the same issue, and a specific worrisome report was from Slovakia, where the social media manager of an organization was completely blocked from Facebook for a month, allegedly from promoting financial scams while actually having a report uncovering financial scams. They even tried to contact Meta through a personal partnership and the National Digital Service Coordinator, but this ban was not lifted for a month. Next. So we have a worrisome conclusion, the apparent conflict of interest. Meta makes about 99% of its revenue through ads. Its net income for 2024 was 62 billion, which was a 60-year increase year over year. Meta employs a relatively minuscule number of moderators, mostly relies on automated systems that fail to detect obvious cases of ad fraud, as we have seen. Regardless of intention, this means that the direct result is increased income for Meta by ad fraud. And for example, only the previously mentioned propaganda ads by the Russian entity in the EU generated a minimum earning for Meta of $34,000. Next. So to
Your
summarize,
time is running up. Can you wrap up?
Yeah, of course. Short suggestions that we provided is that Meta should be asked to provide an extensive technical report on how it applies moderation on advertisements. It needs to significantly increase the number of human moderators, especially in underrepresented languages, and it should require manual ad approval in campaigns with suspect themes, and these criteria should be independently verifiable. Thank you a lot.
Thank you so much. Also pointing again to the concrete problems that we're facing. I think it's always important to know what we talk about and why we have the DSA. So now we come to the perspective of the researcher and academic, and I invite Claire Melford, the CEO of Global Disinformation Index, to speak.
Thank you very much to the Chair and the Committee for this opportunity. Spring 2024, ahead of the European parliamentary elections, a network of extreme apocalyptic bloggers spread alarmist immigrant-based stories across YouTube, Rumble and TikTok. Their reward? Over €2 million in ad revenue and the election of significantly more far-right MEPs. The CSO Media Matters Europe reported this in June 2024. The Digital Services Act, the DSA, has the tools to prevent this. Articles 34 and 35 require very large online platforms to assess and mitigate systemic risks related to this sort of disinformation. Article 39 mandates ad transparency, and Article 42 establishes transparency reporting obligations. Enforcing these could have allowed earlier detection of coordinated campaigns and the pressure on platforms to stop the algorithmic amplification and monetization of harmful content. December 2024, DFR Lab analysed how coordinated social media campaigns helped fuel independent candidate Călin Georgescu's rise in the Romanian elections. His campaign hashtag amassed over 1 billion views. Telegram served as a hub, amplifying content across multiple platforms, and paid influencers on FameUp promoted his message without disclosure of their payments. This strategy of pro-Georgescu Telegram channels exactly mirrors tactics used by pro-Russian actors in Moldova's elections. Enforcing DSA Articles 34 and 40, requiring VLOPs to mitigate risks to electoral processes and enabling cross-border cooperation, could have flagged and removed such behaviour sooner. Since 2022, EU Disinfo Lab and many other organisations have been reporting on the Russia-linked doppelganger campaign, as we've just heard. Faked versions of trusted European sites, Der Spiegel, Guardian and others, mixing legitimate content copied and then mixed with fabricated pro-Russian narratives to mislead European citizens about the war in Ukraine, all while earning significant ad revenue. The DSA's transparency rules could disrupt such operations. These are just a few examples of the very real harms to European citizens being experienced daily. The CSOs that report this research and expose these harms, and the parts of the DSA which, if robustly enforced, would prevent these harms. All these harms are caused by the weaponization of engagement-driven algorithms for profit or political ends. They undermine our trust in democracy, human rights, and scientific progress. The algorithms that determine what you and I see in our feeds and the associated adverts are being gamed. These algorithms are programmed to select the most engaging content, to keep us there for as long as possible, to ensure we can be shown the maximum number of ads or buy the maximum amount of things. Engagement is highest with polarizing content. Since 2012, when Facebook pioneered the engagement-driven algorithm, the more enraging the content, the more likely it is to get promoted, and the more likely the content creator is to earn ad revenue alongside the social media company. This enragement equals engagement equals ad revenue formula has normalized the extreme and, in effect, chilled the free speech of more moderate citizens. Those who claim we are living in an age of increasing censorship are naming the wrong victim and the wrong perpetrator. It is the algorithm that selects what gets promoted, and it is the more moderate middle who are no longer heard online, for the simple reason their speech is not as profitable. And yet the good news is we in Europe have the weapons in our arsenal to stop this. We have the regulations encoded within the DSA and its associated codes of conduct, which can break the weaponization of engagement-driven algorithms by hostile foreign powers and profiteers. The tech companies have to comply, and the European Commission has to enforce. Reporting from CSOs on VLOP compliance has highlighted inconsistencies. Meta's quarterly transparency reports claimed 90% accuracy in hate speech detection, but did not explain the number. TikTok's September 2024 risk assessment summary contained generalized statements on robust content moderation, but no metrics on prevalence of harmful content or details on algorithmic promotion. The CSO Algo Watch testing revealed TikTok algorithm was 11 times more likely to recommend anti-vaccine content to health-skeptical users, in direct contravention of TikTok's own policy. And the monetization of harmful content continues due to the challenges of an opaque digital advertising system, estimated at 80 billion euros per year. Much of that system is not covered by the DSA. Programmatic digital ad campaigns often run over 40,000 websites, sometimes with the involvement of 50 or more intermediaries, making it challenging for advertisers to know where their ads are appearing. This complexity and opacity can lead to the inadvertent funding of unsuitable and illegal material and has created perfect environments for criminals to siphon off billions in ad fraud. Enforcement by DSCs across the 27 member states is also fragmented, as national capabilities and resources vary greatly. At GDI, we consider 6 areas as key. 1. Standardized investigation protocols to help DSCs identify and address violations efficiently, especially for complex cases. 2. Resource allocation frameworks to ensure DSCs have adequate technical expertise, staff, and tools to monitor and enforce compliance. 3. Clear escalation pathways for cross-border cases that require collaboration between DSCs. 4. Transparency requirements for enforcement actions, helping to build the public's trust. 5. Structured engagement with platforms, civil society, and academic experts to improve detection and enforcement. And 6, measurement frameworks to track the enforcement and improve and identify areas for improvement. The DSA is different. It is not like other pieces of service regulation. The online information ecosystem, which it seeks to regulate, is not easily bounded or measured. Instead, it is like the sea for the fish, everything, everywhere, all the time. Regulating the companies that have such huge control over our information space is complex, and by necessity relies on a network of organizations that have the expertise to recognize when the rights of citizens, often vulnerable citizens, are being infringed. This gives CSOs a unique place in the DSA, which is rightly recognized in the Act's text. The CSOs and researchers are the European Union's foot soldiers in the information war. Just as the Russian kinetic war is escalating on the front in Ukraine, necessitating extraordinary measures from Europe's nations to defend their sovereignty, the information war is also accelerating, and this too will require extraordinary measures from those charged with defending Europe's frontline information space. But these CSO foot soldiers are in trouble. They have become the front line. They are under attack. Those who benefit from the unregulated nature of the information space, using it for profit or propaganda, are attacking both the foot soldiers, the CSOs, and the defense shield, the DSA. These attacks, whether internal or external, cynical or misguided, will, if successful, all have the same beneficiary, Russia. 2 urgent steps Europe could take. Firstly, coordinate cross-border enforcement. Disinformation is transnational and requires agile, multi-jurisdictional responses and joint investigative teams and standardized sanctions to prevent illegal content syndication. And 2, formalize the support for the CSO role in DSA enforcement and establish an emergency fund that protects CSOs from baseless lawsuits designed to silence their work. The battle over Europe's information space is real. The tools exist to fight back, but they must be enforced. The EU must ensure that CSOs have the support to continue their portion of this vital work and make the defences in the information war as robust as those required in the real-life war. Thank you.
Thank you very much for this perspective. And now we come to the last speaker. We have, again, as usual, guest here in the committee, the consumer protection organizations, BEUC, and I welcome Agustin Reina, Director General.
Thank you very much, Madam Chair. There are honorable members of the IMCO committee. BEUC has direct experience, first-hand experience with implementation and enforcement of the DSA, both at national and at European level. Obviously, looking at it from the consumer perspective, which are those that the DSA is aiming to protect. Just to give you an example, BEUC coordinated 20 national consumer organizations to gather evidence and launch complaints against the online marketplace Temu, as we found several DSA infringements related to trader traceability, dark patterns, the way Temu recommends products, so on and so forth. So we were very obviously pleased to see the European Commission opening investigations not only under the DSA, but also under the Consumer Protection Cooperation Network, showing the complementarity with European consumer rules. Building on what has been said, obviously, previously, consumer organizations and other civil society groups can play a key role in providing information to the European Commission and the national authorities. So very action against Temu is informed by the very extensive research by our national members, including product testing. So just to give you a very few example, if we go to Italy, our member Altro Consumo in 2024 tested several products, and in the sample of products that have been tested, shown that the majority are non-compliant with EU rules. And this includes products that are marketed for teeth in babies, children toys, balloons, and neither of these products have been compliant with our standards, which could cause suffocation for babies or contain illegal and dangerous chemicals. If you go to Denmark, we also was able to bring information from the testing of our Danish member, the Danish Consumer Council, which also shown that 30 out of 38 products bought on Temu tested did not comply with European safety rules, and that could include products with a very high risk of electric shocks and again on children's safety. And just to show that this problem exceeds our EU borders, our British member, which also found dangerous electric heaters on sale, as well as illegal weapons that were sold without any age verification. And here we're talking about products that actually puts people's lives at risk. At the same time, and particularly because the DSA imposes strong transparency requirements on large players, we can see in the audit reports that have been published last year several concerning conclusions, showing that these platforms do not meet all the obligations under the DSA. For example, and we start with AliExpress, the auditors gave a negative opinion regarding compliance with 10 different provisions, including on the notice and action and internal complaint management, which are rules or provisions that are key to identify and take down illegal and dangerous products on offer. On the question of product safety on the online marketplace, it was also found that this company is not doing what it needs to protect consumers. This also coincides with the research of our French member, UFC Choisir, that have identified extensive use of dark patterns found on AliExpress, but also many other popular online marketplaces in France. In relation to Amazon, it was found that it does not always act in a diligent, objective, and proportionate manner when applying and enforcing its terms and conditions. The reports also reached the conclusion that individuals or entities, like consumer organizations, could not notify during the latest audited period Amazon about the presence of illegal products sold on the platform. When it comes, for example, to Booking.com, it also fails to adopt effective measures to provide consumers with transparency on the parameters of the recommender systems that determine which offers are receiving on the basis of the research on their platform. I could also mention the case of Meta platform, Facebook and Instagram, but was already covered sufficiently. We can only confirm that from a consumer protection perspective, also concerns have been raised in relation of Meta not doing enough to take down advertisers of fake accounts and rogue websites. And as well on the lack of transparency on the content moderation by Meta, which poses difficulties for our members also to report problems identified on the platform. In this sense, BEUC and its members obviously will remain ready to continue supporting the national authorities and intervene in court, obviously, if it's needed to ensure that consumers are not harmed and all players play by the same European rules. We can also not forget the complementarity between the rules that we have on the DSA, but also other parts of the European acquis, notably consumer protection, but also making sure that we have the right enforcement mechanisms in place. Also, in that regard, we look very much forward both to the reform of the Consumer Protection Cooperation Network, where we need to grant more centralized powers in order to act more efficiently and also match the efforts being made under the DSA, but also to the Digital Fairness Act, which was mentioned before. I did not expect to talk about it, but I can obviously mention it because this legislation will hopefully also address loopholes and gaps that have been already identified in the framework in order to better protect consumers in online markets. And then finally, I would like to end this presentation to commenting the work also of the European Commission, both from the DSA teams, but also the CPC and the DMA as well, because we need to acknowledge that enforcing the law in current times is extremely challenging, particularly because of the geopolitical context in which we are living. We also need to know that cases need to be solid to be able to be upheld in court, and knowing that we are basically litigating against the biggest companies in the world. So my final message, particularly to the European Commission, is to honor the mandate that this House and the Member States gave to the Commission when granting exclusive powers to enforce these rules. Because by enforcing the DSA, but also the DMA and other rules of the European acquis, we are not only protecting consumers, we are not only creating a level playing field for companies, we are also protecting the rule of law. And that is what makes the difference between a democracy and an autocracy. Thank you very much for your attention.
Thank you so much to all of you speakers of the second panel. I think also very valuable insights. Now we have again the round of groups, but start first again with our DSA working group chair. Christel.
Thank you very much to you, Anna, but also to all of the speakers here and for the very important job you're doing in helping us making sure that the DSA is enforced. I hear your challenges, I hear the difficulties, and I think it is important for me to tell you that I will also see what I can do to make sure that you're helped in the needed way, because you are a part of the regulation. We wanted the civil society to play a role as well, and we need to make sure that that is possible. So without your work, it would be difficult for users of the platforms to feel more safe. And that was a part of the wish in the regulation. So thank you very, very much. And I wanted also to maybe give the question to the Commission also on what are they doing in order to make sure that you're able to do the work you're supposed to do according to the regulation, and also to .Europe. What can your member organizations do to help and not to avoid the trusted flaggers to do their job? That could be very interesting to hear. Thank you very much.
Thanks, Christel. So now comes the round of political speakers. We start with EPP with Pablo Arias Echeverría.
Thank you very much, Chair. I'm going to speak in Spanish. Bueno, en primer lugar,
first of all, I'd like to thank the speakers from this second panel. I took good note. It was very nice listening to you, but I'd like to ask a question of each of them. First of all, the representative of the Trusted Flaggers on the mechanism functioning. How can we improve this? How is the information received, and how can this mechanism functioning be improved? Because I'm sure that now that you have experience in the forms that you're using to communicate with the Commission and receive the information, how can we improve it from this point of view? And the second thing is for Ms. Melford. When we were in Washington, we were accused of the DSA being a way to censor people rather than something in favor of freedom of speech. And it's not about analyzing the content, but can you just give us your thoughts on this, on what you think about the interpretation, if this is a biased interpretation by platforms, or if we are right, we were on the right track in supporting, using the platforms to support freedom of expression. And finally, for Mr. Reyna, the issue of consumers, regardless of what regulation we have, if we have third country platforms that are sending in products that are not meeting our standards, this isn't going to work. Do you think the regulations we have and that are currently being revised are enough? And final question for everyone, do you think we need more implementation to go further with the implementation of the DSA?
Ms. Kuzenina.
Kiitos arvoisa puheenjohtaja. Puhun suomea tässä yhteydessä. Tämä keskustelu on ollut...
Thank you. I'll speak Finnish. This has been a really interesting exchange of views. very high quality. Now I'd like to talk about the protection of children and young people on the internet. A lot's been said in the European Parliament about TikTok. We've heard that young people are protected, and that's what TikTok tries to do. But in Finland, what we've seen is that a test was conducted. A profile of a young 13-year-old boy called Elias was created, and then they took a look at what the algorithm did for Elias. Now, what happened was that there were images of crimes, of murders and suicide that it threw in his direction. And even though it was reported, that content wasn't withdrawn. So it seems that this isn't a problem for TikTok, exposing a young 13-year-old boy to that kind of content. That's a huge problem. TikTok says it respects the rules, but practice shows that that isn't the case. And that's why we must really think about what steps to take to realize that these are the young people we're talking about.
Very much. For PFE, Mr. Shalabados.
Madam Chair, dear colleagues, thank you so much. We are here today to discuss strengthening of the enforcement of the DSA. But after numerous statements from NGOs, let me ask you directly, is this truly about consumer protection, or are we witnessing yet another step toward expanding the power of bureaucrats or non-elected actors in this system? The DSA does not protect free market or freedom of expression. It has become a tool that allows the European Commission and so-called trusted flaggers to restrict content based on political, let's be honest, political considerations. Who decides what constitutes disinformation? Who defines what is harmful? A narrow group that would censor public debate according to its own ideological agenda. Instead of addressing real challenges such as creating a competitive European digital single market, reducing bureaucracy and supporting artificial intelligence and innovation, we are establishing more regulatory bodies, imposing more restrictions, and introducing more penalties. What's the result? No more security, but less freedom of speech, less competition, and ultimately a weaker continent, a weaker Europe. I believe in our citizens' ability to judge for themselves. That is why I firmly reject the implementation of this DSA and even tighter centralized market control. Let us stand for effective consumer protection and freedom of speech, also in the online space here in Europe. Thank you.
For ECR, again, Mr. Pepera.
First of all, I would say that from what I heard from Mr. Agarwal, he somehow admitted that there was some meetings, roundtables with the member state authorities speaking about the election. So somehow. This means that the scope, the spirit of this Act, Digital Services Act, which is, I repeat, to protect competition and to protect consumers, changes into something else, something which is not intended by the legislator or co-legislators. It's about the freedom of expression, freedom of speech. It's not a regulation which intended originally to do something against the freedom of expression. And the last thing I want to say is the fact that I've seen here a lot of remarks about what happened in Romania. What people which just spoke about what happened in Romania don't know, is the fact that there was no proof, there was no evidence about the Russian intervention into that election. The only proof which is existing in this moment and which comes from fiscal authorities from Romania, it's about the intervention of a party, of a mainstream party, which is called National Liberal Party, member of EPP.
So now for Renew, Sandro Gossi.
Thank you, Chair, and thanks a lot to all the experts. I got a question for fact review and for Global Disinformation Index. To both, I would like to know whether they sent their findings to the European Commission. I think that the report was very interesting. I would like to know whether they sent these findings to the Commission. To the representative of Fact Review, Chair has always told us that Meta is paying lip service to its obligation. I think if it is confirmed what we have heard, it's very, very alarming, because no moderation measures would have been taken, especially to moderate in languages different from English, which was one of the major priorities from our perspective. So, I mean, I would like to better understand whether no measures have been taken from Meta, or if the measure which have been taken from Meta in the cases that you have pointed out were not sufficient. What is, I mean, can you explain this, because it wasn't clear whether there were measures not sufficient or no measures. To Claire Welford of the Global Disinformation Index, I would like to also to understand from her perspective, I mean, did measures were specific measures taken in all the very disturbing cases that you have pointed out? You have enumerated a series of cases where obviously there were a violation of the moderation measures, and I think that we should know better whether any measure or insufficient measure were taken, and you basically telling us that there was no or very insufficient adaptation and compliance from the very large online platform to DSA when it comes to protection, the pluralism in the democratic debate. Can you dwell a little bit more about this? Thank you.
Thank you so much. For the Greens, Eva, Kim van Sparentag.
Thank you very much, and thank you so much to the speakers. And as you've heard, there's a lot of wrongful information going around about the Digital Services Act and about what you have to do. So I was just wondering if maybe our speakers can explain to us how often they think they had to, because of the DSA, infringe on the freedom of speech of people, and to what extent they are harming our democracies. Thank you.
Thank you so much. The left is not there, so ESN.
Ja, ich möchte eingangs noch kurz meinen Verwundern.
Just, I'd like to briefly express my admiration for the colleague from Finland about the 13-year-old Elias and these war images. Talking about this, when you're talking about countries spending hundreds of billions on defense, I'm a bit amazed by that. I think we should pull back on that and not spend so much on arms, then we'd have less war images. Now, for the speakers, the trusted flaggers, I have a question. I'd be interested in the companies. Have your companies been set up specifically to act as trusted flaggers, or have you a longer track record? And I'd also be interested in the people who are responsible for you in your companies. Are they lawyers or prosecutors, public prosecutors, and so on? And what sort of background do they have? And in regard to the answer of the Commission earlier, I'd like to know whether you have come across cases where complaints have led to content being uploaded, where errors were detected in, or that there had been political influence.
All the speakers or all the MEPs, I have much more requests for the room, but sorry, we have to stop now. We only had time for one round of political groups and have to go back to our panel. So we do it in the same order and start with fact review. So I don't know who of you wants to start.
Okay, so I was able to get quite a lot, I think. The common theme I gathered from some of the speakers is the issue of censorship, and to this point, and to any concerns about whether trusted flagging is about censoring speech, I cannot change the the perspective someone has on the topic, but what I can say is that trusted flagging is specifically about locating potentially illegal content, analyzing what that content is, and producing reports about how this can be escalated through the digital services coordinators and the EU. We do not cover content that is about political speech or content that is about opinions. It's just about specific content that is potentially illegal and dangerous. For example, as my colleague explained in his presentation, we have covered a specific case of pseudo-scientific devices, allegedly medical devices with certification. We have covered cases of anti-cancer cures that fall under the umbrella of alternative medicines. We have coordinated with the proper authorities in Greece to produce warnings for the public, and we have included all of this in our report. So this is the kind of work we do in the context of trusted flagging, not censoring speech, not covering political opinions, or anything of this sort. Now, another question that I caught, I'm very sorry if I missed something, there were quite a lot, was if our company was set up just for trusted flagging. That's a no. We're a fact-checking organization. We have been certified by the International Fact-Checking Network from the European Fact-Checking Network. We are members of the European Digital Media Observatory, and our work is primarily focused on fact-checking. The work we do as trusted flaggers is in collaboration with that, but as my colleague explained, the topics we cover under the trusted flagging work is quite different from our fact-checking work. I'm trying to think of another question. I think it had something to do with Facebook, but I'm sorry, at the moment I'm blanking.
I mean, if not, we can also try to see
Sure.
a follow-up in writing or something. Yeah, or you talk bilaterally after.
The mechanisms that Facebook uses, do you want to?
So I didn't mean to say that Meta doesn't do any kind of moderation. It has, I believe, much more limited moderation in non-international languages. So besides English, Spanish, French, such languages, there are much fewer moderators, and so a lot of things are being missed. But even in English, perhaps too little moderation is done. That's my view.
And if you'll allow me, I just remember something. There was a question about whether or not the report had been sent to the Commission. I believe so, since we sent it to the digital service coordinator of our country. So I think these are being escalated to the Commission, if I'm not mistaken.
Thank you so much for the explanation. And now I give the floor back to Claire Melford.
Thank you. I'll try to be brief, and apologies also for missing probably a lot of questions. There was one around whether platforms have a biased interpretation of supporting freedom of expression. Platforms have one job, which is to make money for their shareholders. So they will design their products to maximize the engagement of their users and maximize the advertising revenue that provides that return to their shareholders. So I don't think it's right to consider a platform as having a bias other than providing dividends to shareholders. What that means is that the most enraging content, the most polarizing content, is always what will be preferenced by the algorithms. There was another question on have we sent findings to the Commission? Yes, we have been part of many of the reports, I think, that Prabhat Agarwal cited in his intervention. And there was a specific question about whether some of the cases I mentioned, whether sufficient measures had been taken. I think that's very hard for me to answer. I think in many cases there is a lot of progress being made by the platforms in transparency, in reporting, and in disclosing things around ad libraries, but it is clearly insufficient, and that will continue to be the case while the algorithms that choose the content, select the content that we see, and make the decisions about what content gets ads next to it, while they are entirely based on engagement above all else, and there is no other independent data brought into those algorithms, we will never break out of the cycle of enraging content being promoted above all else.
Thank you very much. And last but not least, Augustin Reina.
Thank you, Madam Chair. Others are more qualified than me to talk about free speech issues, but what I can say emphatically is that the DSA is about consumer protection. This is recognized in the very same legislative objectives of the DSA. It's an instrument that has been adopted under the single market competence, and Article 114 of the treaty, which requires a high level of consumer protection. And I can tell you very honestly, by all the work that not only my colleagues in the BEUC Secretariat, but also our members are doing and investing in identifying unsafe products, this is about consumer protection and product safety. To address your point, Mrs. Arias Echeverria, on the third country platforms, I believe we have to be bolder. If these companies do not respect European rules, European standards, we should put on the table where they should operate and have access to our European markets and our European consumers. People, when they buy products online, especially in Europe, which we are used to having high levels of standards of consumer protection, expect these products not to harm them. The evidence is overwhelming that all these products, or the wide majority of these products, have a high chance of harming people. And I believe we don't need to wait for the death of a toddler in order to act. The evidence is there, and we have also the tools to be bold in this regard. And then the very final point about what the national authorities obviously can do through the different procedures is, first of all, to allow to provide input on the investigation, but also get feedback about how the data that we are putting into is being used, and ultimately to have obviously the rights to be heard throughout the procedure. Thank you very much.
Perfect. So thanks also to the speakers of the second panel. And again, we reached the end of our very exciting hearing. I think it showed again that the majority of this parliament and this committee is very committed of a thorough implementation of the DSA, and we are checking very carefully that the Commission is doing its job. But of course, we also take the different experience of different stakeholders into account. So thanks to all of you. I think it was very valuable. But again, not the last time, I would say, that we had the DSA on the agenda, because a lot of new challenges were mentioned, e-commerce, minors, and so on. But this is probably also a good bridge to our next topic, where we discuss e-commerce, but probably we do like a 1-minute break. We say goodbye to everyone who doesn't want to stay in the room for our regular committee agenda, and then we continue in 1 minute. But thanks again to everyone. I think it was an excellent hearing. Thanks also to the Secretariat.